We are streaming.
All right, I will call the meeting to order. Tim, would you take the roll, please?
Yes, Joe Corbin, EJJ Kennedy,
Here.
Barry Lindahl,
Here.
Catherine Lucas, here, Luke Mark,
Here.
Joel McRae,
Here.
Monica McHugh, Jackie Schnellen. We have 5, so we do have quorum.
Thank you. The first item on the agenda will be the approval of the agenda.
I'll move. Second.
Motion to approve the agenda. All in favor, say aye.
Aye.
Aye. Any opposed? Second item on the agenda is the approval of the December 19th, 2024 minutes.
So moved.
Second. Motion to approve the minutes. All in favor, say aye.
Aye.
Any opposed? Next item is public forum. Monica is not,
So I did not receive any request to provide public comment remotely. I will check one last time, but I do not have any requests for remotely. I believe everyone here is for specific cases.
all right. Excuse me. Next item on the agenda is comments from the board chair. Is Monica on?
She is not able to make it.
All right. And I don't have any comments as the deputy chair. So we'll move on to the consent agenda.
So we have the 2 dismissals under the consent agenda. We just need approval from the board unless there's anything they want to pull out and discuss separately.
I'll move. Second.
All right, we have a motion to approve the consent agenda dismissals, just the dismissals.
Yeah,
I
we do.
object to that.
I'm sorry, who is this?
I'm objecting to that dismissal based on misconduct. This is Tim.
Tim, we are not at your case yet. We are working
Oh, okay.
on.
Okay, I got you. Never mind. I'm sorry.
Thank you.
All right, we have a motion to approve the dismissals on the consent agenda.
So moved.
Was there a second?
Yeah, we have.
Yeah, okay.
We have a motion and a second, did we not?
I have EJ and Luke.
Yeah.
All in favor, say aye.
Aye.
Any opposed? Next item is the acceptance on the consent agenda, one acceptance. I believe.
So we have one acceptance. Again, these are our pilot project where we're doing the facial review. On the acceptance, you just have basically the general information about what the complaint was to accept the acceptance.
I'll move the acceptance on the consent agenda.
Second.
All right, we have a motion to approve the acceptance on the consent agenda. All in favor, say aye.
Aye.
Aye. Any opposed? Motion passes 5-0. All right. We are now at the advisory opinions. There's one advisory opinion on the agenda.
And Kim will be walking you through that.
Yes, so you have advisory opinion 24AO 0014. The question that's presented is whether a government body is required to produce body cam video and lifeguard statements in response to a public records request pursuant to Chapter 22. So if you read through this advisory opinion in advance, you know that this is the result of a very unfortunate situation where a minor child drowned at a local swimming pool. The report that was used to investigate the incident was closed, no charges were pursued. The report includes a body cam video and it also includes a lifeguard statement. So the question is whether those need to be disclosed pursuant to Chapter 22 requests. There are 3 specific questions that were generated from this overall request. So is the city required to release the video as public record? If the video is released, can it be redacted? And the costs associated with redaction, including blurring software, and we'll talk about that, be included as the overall cost for production. And is the city required to release the lifeguard statements as public record? And if so, can those be redacted? So we're going to start with the video itself. Is the city required to release the video as public record? Probably not surprisingly, we always start our analysis with Iowa Code Chapter 22.7, which lists all the different exemptions. And so in this case, we looked at an exemption for peace officer investigative reports, as well as an exemption for medical records. And so our analysis begins with a peace officer investigative report because the video is part of a peace officer investigative report. So we do believe that 22.75 applies because it's a peace officer investigative report. But as we know, that's not the end of the analysis. We also have to determine if the Mitchell balancing test would allow the exemption. So we did apply the balancing test, and we looked at the different facts of this case. As we know, the video does show the minor child receiving medical care and CPR. While providing the medical care, there are also parts of the child's unclothed body that can be viewed. It also shows the child receiving medical care both in the ambulance and in the hospital. So we determined based on a balancing test that first of all, there was an absence of matters of public interest under the Mitchell test. But I think more importantly, we determined there was potential harm attached to the release of the video due to the privacy interests of both the minor child and the family. So we determined there was no public interest that would benefit from the disclosure of the video under 22.7. So we then moved into the medical records exemption, which is Iowa Code 22.72. Because of the fact that this video follows the child getting that treatment, then in the ambulance, then in the hospital, and there was actually within the video discussion of medical status and the different medical components, we determined that under 22.72, the video could also be deemed confidential, separate and apart from 22.7. So once we understood that yes, it can be retained as confidential, we looked at whether it can be redacted and whether the costs associated with that redaction, including any blurring software, can be included and charged to the requester. So first of all, we noted that the city, as the lawful custodian of the video of the record, could disclose it if they so choose. And if they do, that they are allowed to charge redaction costs, and we cite to the code provisions that allow for redaction, and that would include any blurring software purchased that or a vendor applying that blurring software if they were to release that video, and that's obviously they did here. So that was our analysis of the video. So then we looked at the lifeguard statements, which were a little bit interesting because they were developed pursuant to a specific section of Iowa Administrative Code. And that is under the Department of Public Health at 641 Iowa Code 15.47. And it's a report that has to be filed in regards to swimming pool and spa operators. So basically anything that is death and a drowning incident, severe injury has to be reported pursuant to that report. So we said, here's our analysis is, if that report was developed for another entity, filed with that entity, created with, for that entity, under the specific administrative code section, that entity would be the lawful custodian, and any request should be referred to that other entity. But there's also the possibility that this form was just sort of haphazardly used to collect the lifeguard statement and was not filed with the Department of Public Health. We said, if that's the case, then we need you to apply that Mitchell analysis, that balancing test, to see if it should really be released as part of the peace officer investigative report or not. We just didn't have the full facts of those lifeguard statements, so we really gave them two options. If it is developed specifically for the other agency, the agency be the lawful custodian. If not, it's developed for the police officer investigative report, go ahead and apply the balancing test. So that is the crux of our advisory opinion, and happy to take any questions.
Comments, questions from the board?
Where did that original request stem from for the publication of it? Sorry, I didn't see it in the request for the video.
Who was requesting?
Yeah, who was requesting?
And it's my understanding it's an insurance company.
I don't know, it's a public records
Okay,
request.
I just curious.
Yeah.
I just comment, I thought the advisory opinion is very well written and on point. So
I think it's very helpful.
I will move acceptance unless there's any more discussion.
Second that.
All right, we have a motion to approve the advisory opinion. All in favor, say aye.
Aye.
Any opposed? Motion passes 5-0. Thank you. The next item on the agenda are the cases for board deliberation and action. This case is Bonnie Castillo and Union County Emergency Management.
All right, because I know you guys like Kim better, she's going to present this.
Yeah, this one is interesting. I just want to call out first and foremost, this is an informal settlement. So it's not anything that, to my knowledge, this board has seen before. So it's an informal settlement pursuant to 17A. So you'll know that the petitioner is the Idaho Public Information Board. The respondent is Union County Emergency Management Agency, but we still reference the original case number, which is 24FC0013. The reason why this is an informal settlement report pursuant to Chapter 17A is because at the last meeting of the board voted to move this to a contested case proceeding. So that's why you see informal settlement pursuant to 17A and a different caption and process. So just as a little bit of history, as I mentioned, on December 19th, so our last board meeting, this board voted to accept the probable cause order and proceed to a contested case. Today, we're asking the board to accept this informal settlement or to reject the informal settlement and continue to advance it to a contested case. The foundation for bringing this forward to you as an informal settlement is based on Iowa Code 17A.10. And you can see that in the second paragraph of the informal settlement report. So basically, Iowa law encourages the settlement of contested cases. The specific language is, unless precluded by statute, informal settlements of controversies that may culminate in contested case proceedings, according to the provisions of this chapter, are encouraged. So we did work with Union County Emergency Management Agency to see if we could reach an informal settlement. And they did agree to an informal settlement, and the terms are outlined in this report. I'm going to walk these through so that you understand them fully. Let me know if you have any questions or concerns. Basically, what we said is by February 7th, they have to meet all these terms to the satisfaction of IPIB, or we will continue to proceed to a contested case proceeding. So the UCEMA, which is Union County Emergency Management Agency, will agree to the full terms of this informal settlement in a public meeting of the UCEMA to be held on January 15th, 2025. I can confirm that meeting was held yesterday. The full informal settlement will be read into the record of the public meeting and will be formally approved by the UCEMA. The following statement will be read at the public meeting and will be included in the minutes. The UCEMA agrees to the terms of the informal settlement, further agrees to fulfill all terms of the informal settlement by February 7th, 2025. Failure to complete all terms of the informal settlement by February 7th, 2025 will result in contested case proceeding before the IPIB. The minutes are to be provided to us and also posted on the UCEMA website. The second component is they need to formally acknowledge that a violation of Iowa Code Chapter 21 occurred and give the details of that. That also has to be read into the record, included, provided to IPIB in the minutes and posted on the UCEMA website. We did give them the option to give us draft minutes if they can't get those minutes formally approved at an upcoming meeting of the UCEMA. Finally, they have to develop policies and procedures to address all the gaps that we identified throughout the complaint process. So those include policies and procedures to address notice of meetings, setting agendas, minutes, response to public records requests, closed meetings, and maintenance of existing policies. And those also have to be formally approved, read into the record, and be in the minutes. We also made sure that they understood the informal settlement is just a recommendation to you that you could reject it. And if you do reject it, we'll move to a contested case proceeding. So those were the terms. The county attorney did agree to this, and I can also validate that yesterday at the meeting, they did move forward with all terms of this, and they also approved the informal settlement. So now it is the board's discretion to determine whether to accept or reject the informal settlement. I also want to note that the complainant, the original complainant in this case, was not able to attend today. She did attend the UCEMA meeting last night and submitted comments. Those are in your supplemental packet. She did not agree with moving forward with the informal settlement. So I at least want to make sure that you have her perspective and that you know her comments in the packet. So again, staff recommends adopting the informal settlement, but it is the board's discretion to determine whether to adopt it or to move forward with the contested case.
So she has not approved the informal settlement?
So, Bonnie Castillo, when it moves to the contested case, it's IPIB versus the individual, or the government body. Bonnie Castillo did not, agree to it, but, the UCEMA, and all county, offices involved in it have worked to approve it.
All right, well, do we have anyone from the,
CMA, yes, it
Yeah.
should be on the line. Mhm.
If you are here, you have to unmute yourself. I had to mute everyone.
out there?
I'm not seeing anyone unmute themselves.
All right.
Wait, no, sorry.
Okay. Comments, questions from the board?
And the
Is
original.
it my
complaint-
turn to talk or are we to the case?
No, sir.
Not yet.
Oh, okay, I'm sorry.
The original complainant, she didn't serve on the emergency management board, right? Is that correct? Or was she an elected official? And
She was, originally she was employed there.
Oh, that's right.
But is no longer employed there.
Okay.
I will say that, after the board did vote to move to a contested case last month, this did generate a lot of, action and movement on their parts, and they recognize the severity of it. And that's how this came to be.
It appears to me, and I'm just reading this, that the complaint is first that it took too long and she doesn't believe that the commission fully understands the issues. So that's more than that in her objection.
I think in my conversation with her, I mean, I don't want to put words in her mouth, but yeah, she was frustrated with the process, and I understand all of what she believes was not conveyed. I know Stephanie wants to contest his role, but I do think she's really frustrated.
But I guess my question is moving forward gains what?
So this settlement includes additional requirements beyond what the informal settlement was. The informal resolution, we had been working with them. They hadn't ever adopted it or done, there was some misunderstandings on their part about what they needed to do. So this one goes above and beyond and requires them to put in place policies for all of chapter 21 and 22. So we believe that it helps address some of the concerns for why we went to the contested case and why it was, we felt like this, now there's some additional help in the county to make sure that they have those, to make sure that for the public, the requirements that are 21 and 22 are met. Some of the concern that we had was that if they weren't responsive to us or weren't able to comply with what we were asking, how is the general public served? And so with that, a lot of the discussions in this settlement, and Kim was involved in those, I don't mean to speak for you, but a lot of the discussion was, okay, we need to go above and beyond and ensure that if we're doing this, we're putting in place things so that we don't have another complaint. You're putting in place how you're going to address 21 and 22 issues, because we have a lot of concern.
I think also to your point, if we were to move forward with the contested case and didn't adopt the settlement, you would have almost what would be like a mini trial. Now that's something that IPIB has not done a lot of historically. As a matter of fact, we've only found a couple of cases ever. But basically we would have to serve a petition, they would have to file an answer, we would present evidence, we would have witnesses, and we would bring them out for you. And then there's like a roster of remedies that you can use within 17A in a contested case proceeding.
But I guess my question is, if we go through all that, what have we got that we don't have now? I guess.
So that was why we were working. We thought the settlement was, we're recommending the settlement because we feel like this requires them to put in place things versus the contested case, which would just verify that they violated it and have some remedies there.
That answers my question.
At the last meeting, you had a lot of doubts whether they would be able to proceed without having a reoccurrence. Given what you've gone through, is your confidence changed? That you do now have more confidence in the county?
So I could let Kim speak to this. So in my reviewing this, I think that there is more confidence because instead of, they recognize there was a violation, but here they're actually putting in place policies and procedures. Again, they have to follow them, but they will have the tools to help, I think, avoid in the future. I think there's also been a learning here that it's something that is very important and they can't just not respond to these kind of things.
Other comments, questions? How
Given
often have we approved informal settlements where the complainant doesn't agree with it? Not very often, right? But we have.
We have, yes.
Oh, this would be, I'm just thinking that would be an informal resolution for a complaint versus a contested case proceeding, right? So a little bit different there because the complainant is still, for all practical purposes, the petitioner. Now we're the petitioners. It's a little bit different, but yeah.
I didn't mean
Yeah,
to.
no, I was just saying, given that Iowa law does ask us to try to resolve it, I would be in support of this informal resolution.
A motion?
That is my motion. I will approve the informal settlement report. Do we have a second? I'm sorry. All right, we have a motion to approve the informal resolution.
Settlement.
Settlement, yeah.
Yeah.
All right, all in favor, say aye.
Aye.
Any opposed? Motion passes 5-0. Next case is Drake Riddle and Page County Board of Supervisors.
Yeah, so this is case number 24FC0068. This is a final report. This has been before you quite a few times. You probably remember this one. These are the issues with the Page County Board of Supervisors. They didn't report or vote correctly. The individual who was taking the minutes correctly pushed it out without actually running it back to the board. But then as we were reviewing, we found out they actually had 2 sets of minutes for every board meeting. Very confusing situation for the public. So everybody did agree to an informal resolution in this case. In response to that, just so you know, we did conduct a training, which was received well. We covered both chapters 21 and 22. The Board of Supervisors created and adopted a procedure to govern the process for developing and approving minutes. It was a good procedure. They also designated a single and official set of minutes. So they worked together. The auditor had shifted to another job, so they have a new auditor. So they're able to work together to identify a single set of minutes. So far, so good. Everything seems to be running along smoothly. And so at this time, the terms of the informal resolution have been met. And we recommend this final report be adopted and the complaint be dismissed as a result. Happy to take any questions on this one.
Do we have Drake Riddle on the line?
Nobody is unmuted.
Anyone from Page County Board of Supervisors?
Nobody is unmuted.
Comments, questions from the board?
Motion to accept the final report.
All right, we have a motion to adopt the final report dismissing the complaint. All in favor? I'm sorry. Other questions or comments from the board? All in favor, say aye.
Aye.
Aye. Opposed? All right. Final report dismissal is approved 5-0. Next case is Tim Ferguson and Scott County.
All right, this is case 24FC0083. A summary of this is on September 26th, Mr. Ferguson filed a formal complaint alleging Scott County violated Iowa Code 22. It arises in the context of an ongoing dispute between Ferguson and the county. In August of 24, Mr. Ferguson filed the first of a series of records requests of the county. The request included several public employees and a private law firm which provided services to the county. There were dates, specific topics. In subsequent emails, this was expanded. The county did release records in response to some of these, asserting confidentiality or lack of response or directions for others. After this formal complaint was filed, the county did respond to the complaint with a list of records that had been provided. And they sought clarification on which records were still in dispute based on the numerous requests they had received. On October 23rd, a list of 2 outstanding requests was provided. Emails exchanged between a specific assistant county attorney and an attorney with a private law firm, and phone call logs between several county individuals and others involved in the dispute, including the 2 attorneys in the first request. After additional communications and parties, the county asserted there were no additional emails. A 41-page call analytics report was released in the same response. A dispute did arise between the parties as to whether or not there could be additional records on an individual's private cell phone, which he had previously used for work. In relation to that, the county provided an affidavit signed by the attorney attesting the only phone calls relevant to the request were placed from the work phone. On December 16, the county alerted IPIB and Mr. Ferguson that an additional email string was located. This string was located by the county following an IT search. Previously, the county had relied on the assistant county attorney to review the records and provide relevant materials. The email was provided to IPIB and Mr. Ferguson. The county indicated that all email requests in the future would be handled by the IT department to avoid this issue. In looking at this, despite the broad range of requests made in this case, the parties agreed to the scope of the case and limited the resolution of the 2 specific requests. Those were released. We had a phone call log. We did have an affidavit swearing there were no additional phone call logs on a private cell phone. The county did identify a missing email string after the issues appeared to be resolved. This did cause a concern with the validity and truth of the county's prior response. However, that email was found and eventually provided. And the county also has indicated that all records requests would be using IT searches in the future to ensure this does not occur. And again, IPIB staff finds that the county could be more efficient in their review and production of public records, but ultimately cannot find the county violated Chapter 22 with the disclosure and provision of this email provided to all the parties. Therefore, a recommendation is to find that there is dismiss this complaint because finding no violation. I know Mr. Ferguson is on the line.
Am I able to make comments or are you waiting?
No, you have 5 minutes, please.
Am I able to make a comment? I'm just making sure.
Yes, you have 5 minutes to make your comments.
Okay, well, we have problems because I don't trust the county. On the 7th, I sent Ryan McCord, the harasser who was fired from Des Moines County for harassing his girlfriend who's suing Iowa Now. He sent me an email back on the 8th saying, Mr. Ferguson, I've responded multiple times to this. It is my understanding my office has already responded multiple times to your request for this identical information. He was able to provide his own email to the county and he concealed an email from me, which damages his character as well as damages him as a person and shows bias against me as a person. And for the county for the county to be covering up that email is a violation of the law, as well as attorneys who know it's a misconduct against the code of professional conduct, which gives them a duty to report misconduct. And of course, Ryan McCord turns around and says, oh, it's an oversight. I waited 5 months to receive 2 damn emails. How can you be that incompetent to only provide 2 emails? 2 emails. And all you had to do is go search his email, but they left it in his hands. And so I'm supposed to trust the county now because they're going to let IT do it there. And I don't think Christina gets it. And neither does Ryan or anybody in that office. There needs to be oversight in what is going to be released and what is going to be considered confidential, because I don't trust one of them. And proof is in the pudding right here on the 8th, where Ryan McCord hid his emails from me. Who knows if he's using Snapchat? Who knows if he's using his private phone? And it's hard to believe that he's never used his private phone for his work, because somebody's going to call him. Somebody's going to do something. And for him to just sign it, he thought he would give me 1 email, the less damaging, and then withhold the other one. And there's the rub. You have somebody who's been fired for a position of harassing a lady, misconduct for his job. He already been sanctioned early this year because he can't follow the rules of civil conduct. So I have every reason to believe they will not be truthful, and they will not provide everything that I need, because it's going to be damaging to them and what they're trying to do to me as a private citizen. And I don't trust them for a minute. And I believe that the board should be overlooking all these emails and make sure that they're not withholding anything, because it's like the fox guarding the hen. Who gets to decide something? And I don't trust them based on this, and based on Christina saying, well, it was an oversight. No, it wasn't an oversight. I've talked to state police, I've talked to federal agents, talked to many people. He knows what he was doing as an attorney. That is misconduct. And as attorneys have a duty to report misconduct and to police your own, because if we don't, the whole justice system loses integrity. And maybe one day this individual will be doing this to your child and using his misconduct in his position for personal gain. And that's what that email shows. It shows that he was using his position for personal gain, and even blocking me from talking to the county attorney myself. As an elected official, I should have a right to be able to talk to that county attorney and question her. But Ryan was protecting himself, and that's why he kept that email from me. So I believe that your county board, the board should be overseeing this process to make sure nothing is going to be withheld from me, because I don't know what's not been withheld now, and I can't trust them.
Thank you, Mr. Ferguson. Anyone from Scott County would like to address the board?
Are you asking me?
No. I'm asking if there is anyone from Scott County who would like to address the board. Anybody showing up?
I'm not seeing anyone popping up.
All right, comments, questions from the board?
My question is to staff, about, do we know what the impetus was for the county to find this additional email about a month later, Mr. Lee?
So our understanding, just there was a lot of back and forth with this case where a number of requests were made initially as part of IPIP's fact finding. We went back and forth and we narrowed down the scope of what was being requested. Under the circumstances, we had originally had this on the table for dismissal in December. Shortly before the board meeting, they came and said that they, out of an abundance of caution, they'd conducted an IT search for anything else that might be responsive. They found the email from Mr. McCord, who's the county attorney in question, which was part of the same email thread as another one that had been disclosed. What they said and what's been provided to us is that this was an unintentional oversight, and that IT was able to step in and make that review to make sure that there weren't any other responsive records that needed to be provided.
So they did additional due diligence and then provided it to IPIP when they found it?
Yes.
My understanding, based on the representations, is they had IT do an independent search, so we're not relying on McCord alone.
Sounds good.
Other comments, questions from the board?
The only thing I would offer is, sounds like to me that Mr. Ferguson has multiple issues, none of which we have any jurisdiction over. For instance, if it's a matter of trust the county, we can't say anything about that. He says, talked about somebody's character and the need for oversight, all of which are beyond the purview of what we do. It seems to me that we've done everything that we can do under the circumstances. And I'm comfortable with the recommendations.
You accept the dismissal order?
Second.
All right, we have a motion to approve the dismissal order.
So you're not
comments?
going to,
Sorry,
to
Mr.
check over their work to make sure that they're not withholding more?
No, sorry, Mr. Ferguson, you had an opportunity to address the board. Now the board is taking its action.
The only thing I would suggest, we don't have the kind of oversight.
Right.
It looks like to me Mr. Ferguson wished we had.
Yeah.
I want to explain to him that we've done everything we can under the law. But that may not be an acceptable explanation, but it is the fact.
All right, we have a motion. All in favor, say aye. Any opposed? Motion passes 5-0 to approve the dismissal order. Next case is Curtis Wagler and Henry County Sheriff's Office.
All right, this case is,
Erica, before you start, this might be bad news because I have to recuse myself on this, so we don't have quorum.
so, we had a quorum here. Recusing shouldn't, eliminate the ability to take a vote on this. But we will note your recuse, okay? This is a case, that came before the board related to Henry County itself, in which the board did approve a dismissal of the county as not the custodian of the records and not appropriate. This is the complaint about Henry County Sheriff's Office specifically. Some facts with this: on October 9th, Danny Cornell, on behalf of his clients, the Waglers, did file a complaint with IPIB alleging a violation of Chapter 22. This is in response to a records request for documents and communications relating to a deputy's placement on the county's Brady Giglio list, and a broad request for records related to the county attorney's decision not to prosecute the criminal case. The sheriff did acknowledge this request on May 20th after he returned to the office. On June 30th, the sheriff did provide about 1,000 pages of documents to the county attorney for review. There was a dispute, conflict between the sheriff's office and the county attorney's office. On July 4th, the sheriff did hire a private law firm to seek assistance responding to the records request. A package containing the records was mailed on August 5th, but it was not received by the Waglers. So on August 12th, the sheriff's office did email the records that had been previously mailed. And this consisted of about 7 pages of records. The confidentiality asserted to withhold the remainder. This was about 95 days after the request was made. In the cover letter for the response, the sheriff did assert that all records responsive to the request were confidential, either because they were part of a police investigative file or because the correspondence was entitled to attorney-client privilege. After this complaint was filed, an additional 107-page PDF from a different records requester, which was similar request but slightly different, was also provided to the Waglers pursuant to review of this case. In looking at this case, there is some concern with the amount of time that elapsed between the records request being submitted and when they ultimately were received. There is a minimum of about 88 days that elapsed. We did have an advisory opinion similar to this fact pattern with a different record requester, in that we did look at whether or not a reasonable delay could occur because of a conflict between the sheriff's office and the county attorney. In the advisory opinion, the delay itself was only approximately 60 days. We did state that the outside representation because of that dispute could constitute that reasonable good faith delay, but there was a need to ensure that the requester was informed of that need for outside representation and explain the cause for delay. In this case, through a series of issues that seemed to compound, caused an additional delay beyond what was the delay in addressed in the advisory opinion. Based on this, even though there were extenuating circumstances, there's concern with the small number of documents that were ultimately released and the lack of continued communication on the need for delay. In additional, there is, with the records being withheld as confidential, it's possible that all responsive records that are not confidential were provided. However, no three-part analysis was done on the police investigative file. And so there is some concern whether or not that everything has been provided or if confidentiality has been appropriately declared. So it's recommended for this case to accept so that IPIP can continue on an informal resolution and other worked with the confidential documents to make sure everything received, that they're entitled to receive is received. And I know there are individuals here to speak on behalf of this. There was also a statement in the supplemental. There was an issue with the email not getting to me before the deadline, so it is in the supplemental regarding that.
So do we have counsel for the Wagglers here to address this? Or not? Or the Wagglers?
Danny Cornell is the attorney representing.
I am not seeing anyone online.
Do we have anyone here from the Henry County Sheriff's Office?
Yes, members of the board, could I stand down here so no one has to swivel their chair around?
Sure.
Peter Sand, working in conjunction with Ryan Ellis of Indianola on behalf of Sheriff McNamee, and the sheriff is here with me today. We're both here to answer any questions the board might have. But very quickly, to go over this from our perspective, I did submit this document. It's in the supplemental. There was a little bit of sloppy cutting and pasting from different documents, so it sometimes refers to my counsel because that was a letter the sheriff sent earlier. So when it says my counsel, it means Ryan Ellis and me on behalf of the sheriff. We pointed out the difference in the two requests that were received at about the same time and why there was a difference in the documents provided to the two respondents. And then I did respond to the three bases upon which the board is proposing to open a formal proceeding. We oppose a formal proceeding because we assert that the unusual circumstances with the conflict of interest between the county attorney and the sheriff make this a reasonable delay for the sheriff to understand that there's a conflict, to locate other counsel, and to have that counsel have time to review the materials. The fact that 7 pages were produced to Mr. Cornell shouldn't by itself reflect something wrong with the process of responding to the request. There were a lot of materials to review, and that process is not simply automatically reflected by the number of documents that are ultimately produced. So we assert that there is no unreasonable delay going on here, especially since Attorney Cornell had been granting extensions into late July. The other thing is regarding the Mitchell case. I'm glad we were here for a couple of the things that the board's already heard today. The drowning case that was mentioned, we assert very strongly that there's no balancing test from the Mitchell case or other cases regarding an investigative file on an investigation that is ongoing. And the sheriff will tell you himself, the investigative file that's been requested here is regarding an ongoing investigation. And so that makes this different than the Poole case where that investigation's been concluded. And then there's just a question as to whether under this balancing test, certain things might be provided. I also disagree. I know that this is probably not popular at this board, but I would assert that the Mitchell case concerns whether someone can get into an investigative file in civil discovery in a lawsuit and what that looks like. And, you know, the balancing test is used to decide what comes out of that investigative file and discovery and what must be kept among the parties in that lawsuit and not disclosed to the public, because it wouldn't be disclosed to the public under Chapter 22. Yes, there are sentences in the Mitchell case that might make it sound like it applies to any Chapter 22 request, but I would assert that that's not the proper application of that case. This is a standard Chapter 22 records request. And so I don't think that the balancing test discussed in Mitchell applies to this. Those are my main points. I note that your Scott County case noted that one answer to the problem in that case was getting the IT department to be front and center. Well, the sheriff will tell you himself, he's been to his IT person. The county attorney has directed that person not to respond to his requests for help with records requests. Anyway, that's my piece. Sheriff, did you want to say anything to the
Sure,
board?
certainly, a few things. Thank you, ladies and gentlemen, for having me. My name is Rich McNamee. I'm the sheriff of Henry County. Normally on a FOIA or information request, public information request, it's a really simple process. We gather our data, our case file, if you will, anything linking to that case file. We turn it over to our county attorney's office for a legal review and opinion. We get the answer back. Whenever the county attorney gives us legal counsel on to a release upon that request, we do it. This case was drastically different. We began a case of investigations against Mr. Wagler and several of his family members in late 22. We investigated them up until 2 weeks ago. We've responded to about 45 to 50 criminal complaints against them over the last 18 to 20 months.
And it's ongoing.
And it's ongoing. It's ongoing. It's still ongoing. As of last week, we received another complaint. Where they go, I guess time will tell.
5 minutes. You want to allow them to continue?
Can you conclude your?
I can do it fairly quickly. Yes, Mr. Chairman, I can. Because of the complexity of this, and because of the investigation at hand, my deputy Carlos Lopez was placed on a Brady Giglio list by our county attorney. It's a long story and we'd be for hours. So I'll shorten it and say he's been placed on the list. In June of last year, the county attorney went to the board of supervisors and talked about this Brady Giglio placement. Talked about issues between his personality and my personality for a very simple synopsis. Shortly after that, I received 2 information requests, one from the local newspaper, one from Mr. Cornell on behalf of the Waglers. Within a few weeks, I provided every bit of data I had on those cases to the county attorney's office for review like we normally do. After a couple of weeks, I also sent a request to our IT department to collect all emails between me, any attorneys involved, Mr. Deputy Lopez, and any attorneys involved. After about 4 weeks, I sent a second request to the IT department saying, hey, where's all this data you've been asked to retrieve? And I got a simple response back from the IT department saying, I talked with the county attorney and the chairman of the board of supervisors, and they told me not to release it to you, to give it to the county attorney. So to date, I have not received that data, and I cannot provide it on those requests. In conclusion, I'll say this. I thought there was something awry between the county attorney and I. So I spoke with the law office that Pete Sand works for and said, hey, I need some legal counsel. My county attorney and I are not getting along on this. I can't just willy-nilly give this data out to Mr. Cornell or to the newspaper. And they were kind enough to take my employee, and here we are. They've given me legal counsel on that. I provided data that they recommended I provide, and Mr. Cornell does not like the answers. So with that, I feel like I've done my best to give everything that's required under their guidance, and he's not satisfied.
All right. Thank you, Sheriff.
Thank you for your time.
Thank you.
Comments, questions from the board? So what would be the next step if we approve the acceptance?
Next step would be to review, ensure that nothing withheld is confidential, whether everything has been released that should have been released. The other, I would disagree with the legal analysis on the Mitchell. I think we do have in our advisory opinion, even if it's an open case, that does weigh it in the balancing test in, not providing, however, it's does the balancing test we should still be done to ensure there, but
And then
so
what happens after you finish that review?
after that review, that would be part of the informal resolution.
Yeah,
If anything
okay.
was done, anything that should have been, usually we work with the parties. If we say, this shouldn't have been withheld as confidential, we talk through any disagreement on that. And if it's to be provided, it would be provided to the parties. Once all that is done, then the informal resolution would be done. In this case, it is very unusual circumstances, hopefully not capable of being repeated frequently or others. The board could also direct us to work to ensure that there's some kind of a process in place if this were to occur. However, I think a lot of the issues probably are outside of our scope, more political questions than anything we should be diving into.
I guess I have a question for the sheriff. If the IT department won't assist in this open records request, isn't that justification enough for IPIB to get involved and help resolve this?
Ironically, Mr. Stan and I just recently talked about that because I feel it is. I feel that I've asked for public records from the IT department, they've not been provided.
Is it true though that you can perform the same search? It's just that normally that they're the person who does that.
When the information request originally came in, we discussed that, and quite frankly, the IT department said it'd be a lot easier for me to pull up every email from John Doe than you to search through all your past emails for John Doe. And I said, that's great, and that would streamline the process. And then I received the answer, I don't know, six or 8 weeks later, where he said, the chairman of the board of supervisors and the county attorney said not to give that information to you. So yes, is the answer to your question.
So I think that there is a need for IPIB to get involved. You know, at this point, it's an acceptance. We're not affirming stating that there's been an absolute violation. It gives us the opportunity to help maybe work this system where we have jurisdiction through this process.
You know, I guess I noted when I went through this last stage of the analysis, it's pretty clear to me, reinforcing what you just said, facts warrant acceptance to ensure proper standards have been applied and the way it should be, which would be, if they are, then they fortify to a position as sheriff that you've done everything right. So this is not an indictment. This is, we want to take one more step to assure that you've done it right. Right, then fine. If it's not, then it's not the way I see it.
I agree. Yeah. Other thoughts? All right, can we have a motion?
Motion to accept.
Motion to approve the acceptance order. We have a second.
I'll say.
Other comments or questions? Just a point of order on the quorum. Can you help me?
Yes.
So we have a quorum to hold the meeting, just because she's stepping out of this particular vote doesn't destroy the quorum. We had this issue come up before, so then I looked into it so that if it came up again, we would know how to resolve it.
Okay. It would just be a majority of the quorum.
Right.
Voting. I'm satisfied. Thank you. All right.
And if it comes out 2 and 2, let the air out of retires.
All right, all in favor, say aye.
Aye.
Any opposed? All right, the motion passes 4-0 with 1 abstention.
Thank you, Sheriff. Appreciate you guys. Thanks for coming in.
Next case is Aaron Summers and the city of Pocahontas.
This is an informal resolution report. In this case, there was a complaint filed regarding a closed session at the end of the meeting. This closed session was not on the posted agenda, but did come as a result of a staff report. Ultimately, the parties did come together to agree on an informal resolution. There's no dispute about the closed session. They have all approved the informal resolution in December and have already scheduled training for IPIB to come and provided. Therefore, the recommendation on this is to approve the informal resolution report.
Anyone, either of the complainant or anyone from the city of Pocahontas would like to address the board? Nothing on it? All right, any questions or comments from the board?
I just comment that if this meeting was October 21st, we're only, what's that, less than 3 months. That's pretty impressive to get it to here in 3 months.
So that is our new, under our pilot process. Once it was accepted, the parties were very willing to work together on that informal resolution. So again, this is,
Pastor Gilbert.
You're not gonna drop that one, are you?
That's my line in the sand.
All right, we have a motion.
Call.
Second. Motion, to approve the informal resolution report. Any other comments or questions? All right, all in favor, say aye.
Aye.
Any opposed? Motion passes 5-0 to approve the informal resolution. Next case is Matthew Rollinger and Lynn Marr Community School District.
All right, this is case number 24FC0104. In this case, IPIP did receive a formal complaint on October 31st. This was approved. The acceptance was approved by IPIP at their meeting on November 21st. In this case, Mr. Rollinger requested public records from the district related to emails between two staff members on specific times. The district did acknowledge that. The request was expanded. I would ask Mr. Rollinger to mute until it's time for him to speak, just so we don't get the feedback. Thank you. He did expand his request to provide emails and texts from other identified staff on specific dates. In regards to that, the district did provide an estimate of fees that was paid by him. And he did follow up on October 18, 28, and 31st. Each time the district did respond and indicate they were working on his request. He did file the complaint on October 31st. The district provided the requested public records on November 4th. On November 5th, the district indicated all records had been provided with the exception of records withheld due to confidentiality requirements. And they indicated they would complete another review and follow up at the end of the week. On November 8th, the district followed up and provided 2 additional emails the district believed could be redacted as opposed to withheld. The redacted emails were provided. Mr. Rollinger did obtain texts and emails from other sources other than the district. These texts and emails included communications within the scope of this. He believes the texts and emails obtained from other sources are evidence the district failed to provide all public records requested. The district maintains these additional communications were withheld due to confidentiality exceptions or part of the duplicative communication provided. The 2 issues regard a series of texts between employees of the district and emails from a parent to the school. In regards to the series of texts, the texts come from another employee's text message but are the same content. Mr. Rollinger argues all text messages should have been included even if duplicative. Iowa Code Chapter 22 does not mandate that all duplicative versions be provided. He did obtain the content of the communication and duplicate version would not provide any information already received. The emails provided by Rollinger are from a parent to the district. Because these records are from a parent and therefore can disclose information regarding a student, these records were confidential to the school district pursuant to Iowa Code Chapter 22 and FERPA. It's recommended, based on this, the board dismiss the matter without the probable cause for legal violation has occurred. The district has provided public records in response to the request or has provided a justification for withholding public records. District is strongly encouraged to develop a retention policy for public records maintained on personal devices, but it does not find a violation there.
All right, we have Mr. Rollinger on the line.
Yes, sir. Can you hear me?
Yes, we can. You have 5 minutes to address the board, please.
Thank you for taking the time today. This complaint is very simple. My complaint was that I requested certain records, and the complaint was that not all responsive documents were supplied. The district's attorney, in communicating back and forth through this process, one agrees that the communication of a specific text message from an administrator to another employee of the district was public record, has agreed that it was public record, has agreed that it was responsive to my request, as she stated to IPIB that had the text message not been deleted, that it would have been supplied, which means it was responsive to my request. But in that statement also agreed that that document was not supplied. That's my complaint in the nutshell. They also go on to argue that the text messages that were deleted do not violate Chapter 22 2022 because the district does not have a written policy on retention of those sorts of documents. And all of that is true. The district doesn't have a policy in relating to that. And I agree it is not in chapter 22. However, it is in chapter 305 that the IPIB does not have jurisdiction over. Chapter 305 certainly has requirements for retention policies that the district must have. So a violation of another state policy or law does not give the district free reign of violating chapter 22. Again, in a nutshell, I asked for records, they were not supplied, and the district agrees to all of that. On some of the other records that I was concerned with, that privately were sent to me after my request from someone outside the district, the district is saying that those emails were protected under FERPA because a parent of a student sent those emails. I will like to state that there were emails sent from other parents, emails and text messages from other parents that were supplied in this FOIA request. The one that they're specifically saying falls under FERPA and why it wasn't supplied I supplied it to IPIB, and you can read through it. There is absolutely no mention of any single student in any of that communication. The district, even in their reply, stated that this email communication and any reply to it would be subject to public records requests. So the argument that they're being held under FERPA is just plain false. You can read those emails for yourself. Like I said, I have supplied them. As for the text messages that were not sent of duplicated nature, again, some of the communications that I got were duplicated and some were not. This one specifically was not. And again, this text message was sent by a parent of the district of a student with special needs, but it was supplied to me in my request. So it's very obvious that there are some documents here that just flat out were not supplied, that were responsive to my original request. And again, the argument of the not having a requirement in chapter 22 for retention of these sorts of documents is, again, doesn't fall under IPIB's jurisdiction. So it really has no bearing on this complaint. The complaint was for records, all records. I did not ask for duplicates to be removed. I asked for and paid for all responsive documents, and I didn't get them.
All right, thank you, Mr. Rollinger. Anyone from the Linn-Mar Community School District who would like to address the board? Going on there.
Oh, there's somebody who unmuted themselves.
Yeah. Hi, good afternoon. This is Miriam Van Hukelum with the Allers and Cooney Law Firm on behalf of Linn-Mar School District that we would like to address the board.
Go ahead, you got 5 minutes.
Okay, thank you very much for your time. I just briefly want to address the comments that Mr. Rollinger made, if there were some misrepresentations of the district's position. First, with regard to the text message that Mr. Rollinger references from an administrator to a subordinate employee, as laid out in the district's response to IPIB and agreed upon in the proposed dismissal order. Yes, a text message between 2 district employees would be a public record, but is only subject to disclosure to the extent that it exists at the time the request was made. In this case, the request was made several weeks after the communication had been sent, and this administrator had practice of regularly deleting text messages. We did note in IPIB's order that although, or the proposed, that although IPIB does not have jurisdiction over record retention policy, nothing in Chapter 22 to that effect, we did note the recommendation to adopt a policy with respect to communications retained on personal devices, and the district wanted to assure IPIB today that they are working on updating their document management policies in accordance with that recommendation. But that record wasn't withheld. It simply did not exist at the time that made. Mr. Rollinger also referenced Iowa Code Chapter 305. That appears to be a reference to an old code chapter that is now Iowa Code Chapter A, referring to state archives and records. It's wholly irrelevant to the district, as the district is not the state, and it's wholly irrelevant to a complaint pending before IPIB. But again, excuse me, the text message that was not produced simply didn't exist at the time. Mr. Rollinger then talks about emails that he received from other sources. The email that he produced IPIB as an example, or as the email that he claimed that it was improperly withheld, and then just told IPIB that it made no reference to any student. In fact, in that email, the parent states, as a parent, a student that utilizes special education services, and then goes on. Under FERPA, which is a federal law governing the privacy of student education records, the district is required to withhold and keep confidential records that contain personally identified information about students, specifically defined as including student name, parent, date of birth, and a list of other items, including any other information alone or in combination that could be used to identify the student to a reasonable certainty. In this case, the email came from a parent of a student in the school district identifying that she had a special needs child in the school district. Disclosure of that email would have led to the identification of her child and identify that child as having special needs. That would have been a violation of FERPA, federal law, and as such, withholding that email under Iowa Code Section 22.7, subsection 1. Finally, Rollinger is correct that there were other emails from people within the district that were disclosed to the district. Diligently endeavored to produce everything that it could without identifying either parents, students, identifying students, or identifying people outside the district by name. And there were parents that did not identify themselves as being parents of students in the district or parents of students with special needs. Accordingly, those could be disclosed under Chapter 22 with appropriate redactions under Section 22.7, subsection 18, and that was when those were disclosed, although with identifying information removed. We believe the probable cause proposed ruling is reasonable, appropriate, and consistent with Chapter 22. Again, the district did everything that it could to release all public records that existed at the time of the request that were not otherwise confidential. Their good faith is shown by the fact that when Mr. Rollinger raised the concern that he didn't believe he had gotten everything in the first round, they did a second review to ensure that they didn't miss anything, and we would ask that the board approve the order that is being proposed.
All right, thank you. Comments or questions from the board?
Motion. I would move recommendation staff, which I think is dismissing.
Approving the probable cause order.
Approving probable cause.
Go ahead.
And the recommendation of dismiss for lack of.
Do you have a second?
Second.
All right, we have a motion to approve the probable cause order, dismissal. Any further comments or questions from the board? If not, all in favor, say aye.
Aye.
Aye. Any opposed? Motion passes 5-0.
Mr. Chairman,
I Probably have to say.
I was wondering if we could take a break.
Oh,
Yes.
I'll second that motion, but I just want to comment. I've had some concern about lack of pension policy or instruction in the code. And I don't know whether, I'm not suggesting we talk about it today, but I guess at some point I'd ask staff or talk to the board about whether or not we should pursue that.
That was my second thought on basically figuring out if there was a way for the legislative committee to take a look at something along those lines and maybe even just make a suggestion.
Did you always go with the most important first?
Absolutely.
Staff has noted the comments of the board and will
Yeah.
move forward accordingly on that.
Okay,
On
thank you.
counts.
Well, it's up to the chair on the first one.
What's that?
If he could take a break, if we can take a short little break.
Yeah, we will be in recess for 5 minutes.
We're taking a
Thank you.
5-minute break, you guys. Thank you very much.
Lights are on.
Unmuted.
All right, we're back in session. The next case on the agenda is Joe Goshi and Cassuth County Supervisors and Auditor.
All right, this is case 24-C0109. On November 13th, Joe Goshi filed his formal complaint alleging Cassuth County Board of Supervisors violated Iowa Code 21. He alleges that this violation was when they voted to send informational letters and add to Cassuth County Drainage District policy the requirement to send an informational letter to landowners of any district at the start of any litigation and a yearly update between when assessments are approved and mailed out. He alleges the item was not on the September 17 board agenda because it only stated Drainage District 80 assessment. At the September 10th board meeting, the board addressed a question raised by a landowner in Drainage District 80 about an assessment received because the cost was not related to any more Drainage District. Most of the cost was related to litigation. The board agreed to consider how to respond to the question raised on that assessment at the following meeting on September 17th. The board said it would address the assessment first and consider following the process for other districts. At the September 17 meeting, during agenda item Drainage District 80 assessment, the board deliberated on how best to inform district landowners about litigation costs assessed to the district. They voted to work on a policy to be brought to the board that would include sending a letter to landowners and district at the start of litigation and again before the district. Goshi said he did attend the September 17 meeting because of the agenda item Drainage District 80 assessment. The issue to be resolved here is not whether the notice given by the government body could have been improved, but whether the notice sufficiently apprised the public and gave full opportunity for public knowledge. During the agenda item related to drainage districts at the September meeting, the board did bring up the issue of the landowner's lack of awareness of attorney fees. The board gathered some information, but agreed to wait until the September 17 meeting to discuss how to address the matter when it could be listed as an item on the agenda. They agreed to discuss the Drainage District 80 assessment. Similar to the facts of the KCOB case, the matter has been discussed at a previous board meeting. Further, the Drainage District 80 landowners have received their assessment and had to ask questions about the cost. Goshi stated that he did attend that meeting because the Drainage District 80 assessment was listed on the agenda. He thought they would be taking up a different issue. Viewed in the context of surrounding events of the community, the agenda item was sufficient to notify the community regarding the discussion concerning notice of the cost. The community had received the assessments. The board agreed at the September meeting to put how to inform landowners about litigation costs causing drainage district assessment on the September 17 agenda. And they even agreed what the agenda item would say at the September 10th meeting. Even if there is a question as to the sufficiency of notice, any error that exists would likely be harmless error. Chapter 21 does not specifically mandate what actions require discussion and deliberation. In this matter, the board responded to a landowner's questions regarding why their assessment was so high and voted to send information to drainage district landowners and create a policy to notify landowners about litigation and costs that would be brought before the board for review and final action. There likely is no need to take formal action to direct staff to send informational letters to Drainage District 80 landowners or to draft the policy to be brought to the board for final approval. The draft policy has not yet been presented to the board for review, deliberation, or action. When it is, the matter will be placed on the agenda. The policy documents will be public records, and the public will have the opportunity to provide input if they prefer a different policy regarding drainage district landowners' receipt of information regarding litigation costs impacting drainage district assessments. Therefore, it's the recommendation of staff to the board to dismiss the matter, finding no probable cause violation has occurred because this question was brought up in regard to a landowner on their costs. The board set the matter for consideration at another meeting, and the board's action was to send informational letters and prepare a policy for review for future adoption. Mr. Goshi is here. He did also provide comments to the board on this matter.
Mr. Goshi?
Yes, have you all had a chance to read my statement? Erica said she provided to you, otherwise I can read it. Take up.
Well, you have 5 minutes. So.
Okay. Well, this matter here is, first thing I want you to know is on the Cassuth County Board's Supervisors board packet, they said the Board of Supervisors put that on there. So that means to me, now I put things on this agenda. And what that means to me is that you can call any one of those supervisors and they know what is going to be talked about. on that item. So therefore, they had to get together and talk about it. The other thing is, when you look at the agenda, you can't correlate a policy informing the landowners about notification of lawsuits by the agenda item that was put on there. Plain and simple, it's black and white. And these are not tentative agendas. They're not tentative records. They've all been approved. Now, in my summation, I go through a long list. Now, I'm on DD80, and I get those bills. And I asked for the receipts for the bills, and there was no legal fees on any one of my bills presented. I can tell you, and I'm on DD80, so I should have gotten it, and I watched these bills. So whatever they came up with about, landlords asking, I'm going to tell you what goes on in the auditor's office. I got 4 lawsuits against these guys. This is what the auditor will do to you. If you want to file an appeal, you got 20 days to get a bond and get it filed with a bond, which this auditor did, and you can check in the lawsuit. It's on DD4 lap 2. She withheld that information until the very last day, and I could not record that appeal in time to the judge, but the judge allowed it because of the Auditor's Act. And they said in that lawsuit that that auditor has to give how much bond is required for an appeal immediately. These are the kind of people I deal with. They'll do everything they can do to skirt the law. Now, and some of their things have cost landowners in Cassuth County big money. They got 7 drainage districts. I'm involved in 4 of them, where they come out 7 or 8 years later and come up with more. They have to assess more. And the historical records don't show that we owe more. And these are big bills. We're facing a $250,000 bill. So these people that want to keep us from going to court just don't want to be exposed. That's what the deal is. And they have violated open records laws on drainage things. I was out trying to discover we had a problem with the main on DD4 line 11. Kyle Stecker came out with the sheriff and tried to stop our investigation because he's protecting the landowner. And as far as I know, Todd Holmes has given training to these people for open records and open meetings. They seem nothing seems to stop these guys from doing what they're doing. So I'm coming before you guys to see how can I get the community to go home to a community where they're open. I knew what was going on. These guys, they did a reclassification, spent $113,000 on an illegal classification, put an impeded impound of watershed in the district, which now we have a right to get drainage fixed to, and they won't do it because they got to face the U.S. Fish and Wildlife Service. They can't go in there and fix our drainage, but we're getting assessed. Why? Because I caught them every step of the way. They start out with DD 80, lat 50, lat 70. It says we already have assessments there. So then they change it to a town outlet. They violated the law there. If you're going to do that, you have to have an approved engineered plan before you can go out and reclassify. These reclassifications cost money. And now they want to tell you that that isn't what it's about. What it is you got a bunch of chickens that don't want to put their name on an agenda and put the agenda out there and not let the public know what they're doing. Guys like me. That's what they do.
That's 5 minutes.
Thank you.
Thank you, Mr. Goshi. Do we have anyone representing Cassuth County Supervisors and Auditor?
I'm not seeing anyone.
Okay. Comments, questions from the board?
Was Was there a board recommendation for this? I didn't see it on the.
Yeah, I noticed that it's the recommendation is dismissal. It doesn't specifically state, that in that last paragraph. But that is the.
Want to add that to the report?
Yeah, I will add it to the
Yeah.
report.
Is it worth on this one, what we did last month or the month before, asking the county to come in here? So we can just tell them, you need to do a little better too.
I wonder if that.
You know, just that they can do more on their agendas than give the most vague answer possible.
Table it for the county to come in and get their perspective on this. Or is table it, maybe not even know.
Absolutely. Do that. I will say that I did watch the September 10th meeting and the September 17th meeting. And it was discussed at the September 10th meeting.
Okay.
The IPID complaint or just the
In
assessment?
September 10th, they brought up the question about the assessments and the litigation costs. They said they were going to put it on the agenda the next month to discuss how to provide information to the landowners in that drainage district. They said we're going to put it on the agenda as Drainage District 80 assessment, is what it was stated in the September 10th meeting that I watched.
Are those online?
Yes.
When did they send out the letters?
I'm not sure exactly what date those went out. In the September 10th meeting, they said they had a question from, I don't recall the individual's name, about why there was an assessment and no work done.
Well, so right now the recommendation is to approve the probable cause report dismissing the
Yes,
complaint.
if you want us to table, yes, if you want us to table it, to bring the county in, we can certainly do that.
I think there's merit.
Yeah, I do too. Yeah. I would say. Yeah.
It's nice to have young thinker.
So do we have a motion to table
I'll move.
to the next meeting?
I'll move to table to the next meeting.
Okay, the motion made, seconded to table it to the next meeting. Any other comments? All right, all in favor, say aye.
Aye.
Any opposed?
Aye.
Opposed. One opposed, or the vote is 4 in favor, 1 against. Yeah.
All right. I will fix that for next time.
Okay. All right, the next case on the agenda is Michael McPeak and the Iowa Department of Direct.
So in this case, I did receive a formal complaint from Mr. McKee alleging the Iowa Department of Corrections violated Iowa Code Chapter 22. Mr. McPeak is an incarcerated individual currently in the custody of Department of Corrections. He had requested and was denied access to a copy of the drug testing instructions used by the department to test incarcerated individuals for illegal substances. He alleges the drug testing instructions are public record and the department violated Iowa Code Chapter 22 by refusing to provide those instructions. In reviewing this, McPeak alleges a violation of Iowa Code 22. The department maintains that drug testing instructions in question are not a public record, are exempt from disclosure as an internal investigation pursuant to Iowa Code Section 904-602 2K10. In that section, the department is granted broad authority to govern its internal administration. Specific records are exempt from public inspection requirements under Iowa Code 22. These include records including procedures on inmate movement and control, internal investigations, and contraband and medicine control. Based on this, the department has the ability to exempt as confidential drug testing instructions used to detect the use of illegal substances by incarcerated individuals. Based on this, IPIP does find that drug testing instructions would fall within that Iowa Code 904-602 2K10 and does make a recommendation that the board dismiss the matter for lack of probable cause for legal violation has.
Do we have Mr. McPeak on the line?
I do not believe he would be. I don't know if there's anyone else on his video on the line, but I'm not seeing anyone, unmuting themselves.
All right, do we have anyone from the Iowa Department of Corrections?
Yeah, my name is Mike Spall. I'm general counsel. I just want to thank you and the staff.
Comments or questions from the board? Pretty straightforward. All right. Motion and a second to approve the probable cause report dismissing the complaint. Any comments? All in favor, say aye.
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 Any opposed? Motion passes 5-0. Thank you.
Thank you.
Next case is Keegan Jarvis, from Swan City.
In this case, Mr. Jarvis filed a formal complaint alleging the Swan City Council violated Iowa Code 21. The city is involved with ongoing civil litigation with the complainant out for reasons outside the scope of our jurisdiction. Pursuant to that, on November 4, 2024, the city passed out copies of interrogatories to be completed by each council member as part of civil discovery, and that's in the case after adjournment of the meeting. Jarvis contends this after meeting session constituted either an improper closed session or a meeting without proper notice beforehand. The city argues there's no improper meeting as there was no discussion amongst council members either immediately after adjournment or in emails thereafter. In this case, it is undisputed between the parties that no substantive discussion occurred. State council members briefly received information with instructions to review the documents on their own time. Based on this, it is recommended the board dismiss the matter for lack of probable cause to believe a violation of the code. Council members passively received information and documents, and the complainant does not allege a majority of members ever shared deliberation on any matter amongst themselves. Nothing that happened after adjournment would qualify as a meeting.
Do we have Mr. Jarvis on the line? No, anyone from Swan City who would like to address the board? Comments or questions from the board? Pretty straightforward. Can I have a motion, please?
I'll move.
A second.
Motion is in a second to approve the probable cause report dismissing the complaint. Other comments? If not, all in favor say aye.
Aye.
Any opposed? Motion passes 5-0. Next case is Timothy. Is that the complainant?
Timothy John Miller.
And
No,
there's a semicolon there.
there's a semicolon.
Okay. All right.
So
And the City of Waterloo Police Department, sorry.
So on November 27th, Timothy John Miller filed this formal complaint alleging the City of Waterloo Police Department violated Iowa Code Chapter 22. The IPIB accepted this complaint on November 27th. Miller alleges the department failed to comply with records, data, and video requests for legal and lawful requests, willfully denying public information to commit tortious constitutional fraud in an attempt to force some fictio juris unconscionable contract. The records custodian for the department responded to the complaint, provided a copy of the tickets issued and the business cards for the officers as requested by Mr. Miller. The department stated they were not the custodian of dispatch center records or the original autographed copies of the citations, and provided the name of the appropriate agency and the clerk of court. Miller alleges the documents provided did not include his addition of, quote, all rights reserved above his autographs of documents are Photoshop manipulated documents, which is a felony. Miller had sent by certified mail a confusing document that included a records request to the officers involved in the issuance of 2 traffic tickets to Miller. The request is included in your order. Miller mailed a notice of default, cure, or quit within 72 hours on September 18th. Upon filing a complaint with IPIB and providing information regarding the records request, IPIB submitted the request to the department's records custodian. The public documents within the custody of the department were provided to IPIB and Miller within 12 days, which also included Thanksgiving holiday. Miller was also directed to the custodians of the records, requested records not within the custody of the department. While there was some delay between the original records request made directly to the police officers and the IPIB communications to the publicly designated records custodian identified by the department, the delay between submission of the original request and when the requests were submitted to the appropriate individual is not unreasonable. Miller's complaint regarding the fraudulent nature of the documents is Photoshop manipulated documents is beyond the jurisdiction of ICFID. The original records requests were submitted directly to officers employed by the department. Upon receipt of the requests from ICFID, the department's custodian promptly provided the records within the custody department. It is recommended that ICFID dismiss the matter for lack of probable cause to believe a violation has occurred.
We have Mr. Miller on the line.
There's a phone number that's unmuted. I'm not sure if that's Mr. Miller, so we can't hear you.
All right, anyone from the City of Waterloo Police Department?
This is Captain Jason Feeker. If you guys have any questions, I can try to answer them for you.
All right, thank you. Questions or comments from the board?
To accept probable cause report with the recommendation of dismissal.
Second. All right, we have a motion to approve the probable cause report dismissing the complaint. Any other comments? If not, all in favor, say aye.
Aye.
Any opposed? Motion passes 5-0. Next case is Kevin Cahalan.
I think I read it as Callahan.
Yeah, I know.
Yeah.
Alan.
City of Eagle Grove.
So this is case number 24FC0118. This case did take an unusual procedural travel through the IPIB. This was brought to us while we were reviewing another case. While we were doing that, we received a formal complaint regarding the information from Kevin and Rachel Cahalans. On June 2nd, 2022, Ms. Cahalan submitted a records request to the city seeking a signed lease agreement between the city of Eagle Grove and Eagle Grove Recreation. They did receive a response from the city, which included resolution 2022-54 and an executed ground lease. Cahalans contacted IPIB via phone and email regarding that other complaint and provided this records request. They also appeared at our 2022 meeting and asked to speak during the other IPIB complaint regarding the city of Eagle Grove. IPIB worked with the Cahalans and the city to determine why the records Rachel Cahalan had received were inaccurate. IPIB staff did compare the documents to the resolution ground lease and found that there was a discrepancy. IPIB staff did work with the city and their attorney regarding this discrepancy. The links for that when the city attorney were provided to the Cahalans. On January 2nd, IPIB presented the parties with an informal resolution to work towards resolution. The Cahalans stated they had multiple objections to the informal resolution. IPIB met with the Cahalans, and the Cahalans provided information. During that phone call, the Cahalans disputed the factual findings of IPIB regarding the informal resolution. Of significant concern was the Cahalans' dispute regarding the following statement. Pursuant to another ongoing IPIB complaint, the Cahalans recently discovered the information provided by the city in 2022 was not correct. Upon learning that incorrect information was provided, the Cahalans filed a statement. Cahalans argued IPIB had no proof the discovery was part of another complaint, or the Cahalans had recently discovered the information provided by the city was not correct. IPIB had accepted this complaint based on the claim now disputed by the Cahalans that the Cahalans recently discovered they had received incorrect information pursuant to a 2022 records request. If IPIB's factual determination, Cahalans had only recently discovered the receipt of the incorrect information, the current IPIB case addressing, based on the current IPIB case addressing similar documents and projects is that is inaccurate. There can be no jurisdiction for IPIB to address this matter. The city took action to approve the correct lease on May 16, 2022, and any discrepancy in the documents held by Cahalans since June 2022 likely should have been discovered with any reasonable diligence in fewer than 2 years and 6 months. IPIB's jurisdiction to review complaints does not exceed violations outside of 60 days from when the issue could have been discovered with reasonable diligence. Because IPIB has no subject matter jurisdiction, 24 FC 0118 must be dismissed for lack of jurisdiction.
Do we have Kevin or Rachel Cahalan on the line?
Hello, can you hear me?
We can.
Okay, thank
Is
you.
this,
My name
is
is,
this
yes,
Cal-
my last name is pronounced Callahan. Thank you.
thank you.
I became aware of the alleged violations of chapter 21 and 22 Code of Iowa after reviewing the City of Eagle Grove Council meeting minutes from October and November of 2024. This fits both criteria of Iowa Code Section 23.7, file within 60 days and become aware of a reasonable diligence.
Do you have anything further, Mr. Callahan? All right, thank you.
On April
Anyone
20,
from-
yes, on April 21st,
Sorry.
there was a notice in the paper to have a special meeting. They did not have a special meeting per their notice. Excuse me.
Anything further?
I believe she put it all in the file.
All right, thank you, Mr. Callahan. Is anyone from the city of Eagle Grove on the line? Apparently not. Any comments or questions from the board? So this is just the 60-day jurisdictional issue.
Yes,
That's it.
yes.
But he's arguing that he didn't find it till November 24.
When he was on the phone with us, he disputed that, it was only after they received something stating that there was no jurisdiction. They provided information from 2022 to 2024 in response to this. So, we were attempting to assist them in this and we discovered that we really shouldn't have been involved. It was, we really didn't have jurisdiction for the 60 days.
But his argument is you had to go to the date he discovered. He discovered. Is that what he's saying? Is that his argument?
So he's now stating that, in the phone call, they disputed our factual finding that they had recently discovered it. Now they are stating that they have recently discovered it.
But I'm not sure what's left though. I mean, the lease has been provided.
Everything has been provided. An explanation of why they might have received something different has been provided.
And it stemmed from an informal resolution that there was a dispute on the timeline and
So, yeah, so staff was trying to assist in this matter. From that, we did an informal resolution with that. There was dispute about whether or not we even have jurisdiction to do it. And so we really honestly don't. If all of this was pursuant to a records request in 2022 and all of the actions by the city that should have informed them of that occurred in 2022.
So the recommendation is to dismiss for lack of jurisdiction.
otherwise it would have been otherwise if there had been jurisdiction, there would have been an informal resolution to the
Yes.
parties to say, here's the things that need to be done.
Correct.
All right.
I do,
comments?
excuse me, yes, excuse me, I do have a resolution dated 2023 if you're interested in seeing that.
Well, I don't think that would help either. But no, still beyond the jurisdictional limit for the board. So, all right, anything further? Can I have a motion? Second? All right, we have a motion to approve the probable cause report dismissing or lack of jurisdiction. Any other comments? If not, all in favor, say aye. Aye. Any opposed? All right, the probable cause report and dismissal are approved. Last case is Kenneth Brown and the city of Sydney.
In this case, Mr. Brown filed a formal complaint 24C0124 alleging the city of Sydney violated Iowa Code Chapter 22. Mr. Brown had filed a records request with the city of Sydney from October 23 to December 10 when he filed this complaint.
He alleges the city failed to appropriately respond to his request, and he alleges public information requests are being ignored and going unanswered. He did follow up to his request, seeking clarification after he made the request. The city responded to his complaint through your council. The city disputed Brown's characterization and stated the city was going through a period of transition and retraining after the clerk and deputy clerk both resigned with 2 weeks' notice effective September 30th. The city was left without any clerks until the new deputy clerk began on October 7th, and the new city clerk started about a month later. The turnover caused a backlog of reports for the city and some delays and confusion in responding to his 6 records requests during this period. Specifically, the city did respond to Brown's first October 23 request for a recording of the council's meeting on October 31, stating no record existed. And the city stated Brown's request for the clerk's financial report on September 24 was also filed on October 23. Due to the turnover, the report had not yet been prepared and was not completed until after Brown filed this request. The city admits it did not immediately respond to that request because this request was filed the same day as the other request, and admits the fact that it was a separate request. The deputy clerk did reach out on November 15, apologizing for the delay, told Brown the record had not been approved by the council and the request would be processed as soon as possible. The mayor also followed up with Brown after Brown questioned the statement that the council would need to approve the request. The mayor told Brown the city was working through a backlog of reports and getting the report as soon as it was completed. In other words, the document did not exist at the time the request was made, but would be provided as soon as it was completed in December. The city stated it has responded to all of Brown's other requests on or before December 27 when the city responded to this complaint. And the primary issue is the delay in responding to Brown's request, primarily the October 23 request. At that time, the city had a new deputy clerk who's been employed, but when at weeks there had been no one employed in the clerk's office the week prior to their employment. City business was backlogged. The city clerk position was still vacant at the time the request was received. While it would have been better had the city caught there was a second request filed on October 23, acknowledged sooner, the delay and confusion is not unreasonable considering the upheaval. Once the error was identified, the city did respond and explain to Brown why the document was not immediately available, and to their benefit, the city worked to provide the request of the document to Brown, even though at the time he requested it, the document did not exist. Once the document was completed, it was provided. Any error in the delay was harmless error. The city is not intentionally withholding the record. The document did not exist and could not be provided earlier. The city has provided all records to Brown pursuant to his request without charge. The city has also stated it would welcome some training by IPIP for the new clerks to assist them in their new roles to ensure there's no repetition of the issue. Because of the unusual circumstances, a complete turnover in the clerk's office causing a delay in responding to the records request not likely to be repeated, is recommended the IPIP dismiss the matter for lack of probable cause of legal violation has occurred. Mr. Brown did provide comments to the board.
Do we have anyone from the city of Sydney who would like to address the board?
Yes.
Yes, City Attorney Bree O'Hearn is here. I'm happy to answer any questions that you might have. I think that Erica's synopsis of the situation is perfectly appropriate, and her recommended training, I think, is more than welcome by the new city staff members. I think they are open and always willing to learn, and would certainly hope to avoid any further confusion with Mr. Brown as we move forward.
Thank you. So is there a training schedule or will be scheduled?
We is going to work with them, probably do something remotely with the clerks. And then if Mr. Brown wants to attend, he's welcome to attend as well.
Okay. Comments from the board, questions? All right, can I have a motion?
I move dismiss of lack of probable cause of this violation.
Second, we have a second. We have a motion to approve the probable cause report dismissing the complaint. Any other comments? If not, all in favor, say aye. Aye. Any opposed? Motion passes 5-0. That concludes our cases involving board deliberation and action. Matters withdrawn. Do we need to do anything with that?
We do not need to do anything. That's for your information. I just want to say, Alex has done a good job of working to resolve these matters, so that they did not have to come before the board, and making happy people and doing what we should do is resolving disputes quickly and efficiently.
Thank you, Alex.
Great news.
Do you have anything to say about you?
That would be a closed session.
Not noticed. It wasn't noticed. Hold on now.
Pending cases, we don't do anything with that, do
That
we?
is just informational for you so that you know, we have, with this, I will say that,
21 of them.
yeah, so we were at 30 or 40. And so I will say that with this new pilot process, I think, from my perspective, I feel like we're being more responsive, quicker, able to resolve things better. So from my perspective, I like it. I don't know if the board is liking it. I think next month I'm going to make a recommendation that maybe make that permanent so you guys can think about that. But I do, you know, a couple months ago, we had 40 pending issues. So
What you may want to do when you write that, note to the board, brought to you by the legislation committee.
it was by the
To what? To new procedure.
Oh, yeah. Sounds great.
I'm pretty sure it was the.
Tough crowd. I'm fine with you. Legislative committee, we'll take all the credit for that. You guys did tremendous work over there. Tremendous.
I get there. Look a lot of air out of here.
You rode a bicycle.
All right, committee reports.
Alex, any updates on the training committee?
Sure. So we'll be meeting, we'll be scheduling something. My intention had been if Monica and Jackie were here, this is shaming them on record. I know that they're busy for other reasons, but we're going to schedule a committee meeting so we can focus on what our priorities are for developing training materials for the website. I know that right now we have 2 trainings this week. One of the things that I'm working on at the moment is updating our frequently asked questions section. We've taken that down. We're going to update it with new information, and then any other frequently asked questions that need to be added, we can figure that out as a committee. Aside from that, I have nothing.
Just a note, Catherine, we assigned you to training committee since you declined the
easy one.
invitation to be on rule.
Oh, we talked about.
Man, rules never look so good.
Tough crowd.
Great.
All right. Legislative committee, legislature started on Monday. Kim and I are both registered to go up there if there's any legislation, our legislation or other legislation impacting our 21 or 22. So far, we have found one bill that has been filed. It's House File 47. This is a bill that had, we're just monitoring this. It was proposed, or at least it was, we followed it last year. This would make a booking photo a confidential public record under 22.7 unless there's specific facts related to that. So again, that was just filed. We will monitor it and keep you aware of it. The legislative committee last year, at the end of every week, I did provide an update of bills that were related to our jurisdiction and provided those out so you could see what was out there and what the status was, and if there was anything that we had questions or concerns about.
What about the bill that says a wild shark in Iowa that's greater than 23 inches is dangerous?
We should.
I did not pull that one.
According to this bill,
We got jellyfish, I knew that.
we have sharks.
Yes, we do. We do. There is a proposal for a state fish.
Yes.
I did do that, but I don't know what that fish is. I'm not a fisher
This
person.
dart fish, it's about this big. It looks like a minnow.
Okay. I probably would.
Strong feeling about the dart
I
fish.
was going to weigh in on that.
Or the sharks.
Legislative committee convened. We're strong in favor of the muskie. We will not
Emergency.
accept the dartfish, muscalunge or bust.
I hope they spend a lot of time on that, not just with anything else.
Yeah, fireworks.
Then there's the
bill
annexing
the
lower tier of counties. They can keep their hot dish. I don't want it.
No, I just, all right, so, yeah, so our 3 bills were pre-filed. I have not seen them pop up yet, but they have been public. I don't know, there was something in the Des Moines Register about our bills. That's all I can tell you about those.
They were making, went through what this legislature ought to do this session. Our 60-day, was it 60-day one?
I think all 3 of ours were included in that.
It was the like top 5 no brainers or something like that that they should do.
That we decided that.
After they deal with the fish.
All right. Rules? All right, so our rules committee met today. As you probably know, I sent out requests for comments from board members on the rules draft, which is included in the packet as well. Prior to the holidays, for board members that responded, thank you very much. All those issues were taken up today by the rules committee. So the rules committee talked about some of the corrections that were identified. They talked about burden of proof, delegation of investigation, and overall compliance with EO10. What the committee wants to do is take another month, do some due diligence, work through those issues, and we'll meet about halfway between this meeting and the next, talk about that, and then we will get a clean draft out to the board with changes based on the recommendations from board members. So that is the status of the rules committee. Did I miss anything, rules committee members?
No, yeah.
No, we're on. But we do encourage you to have any thoughts, please.
Well, yeah, I just noticed something in 2.1523, the burden of proof. It refers to the defendant, and I think it's simply the respondent that's referred to. So you don't want to revise that.
Yeah, we have quite a few issues, I think, that we're trying to work through with the burden of proof. So one is, we would like to be able to just refer to the chapter itself, but there's a complication in 21. So I think if we can refer back to the chapter itself, that will address your issue. But we also have a problem with 21 in that section only references a closed session for jurisdiction as opposed to a meeting. So we're working through that. I think that your issue will come on the wash with that.
Yeah, and it does say respondent. One part of the sentence says respondent, then it says defendant.
Yeah, it's a judicial enforcement section, since right where that language came from, but we need to clean it up.
You want us to move on?
Yes, I'm sorry.
That's right.
Office status report.
All right, so IFIB office will move, we have just been informed, we will be moving on January 27th. So we have to get our office packed up.
Yay.
And we will be over in the Justice Parker building, on the lower level. They are, I don't know. They'll have 2 conference rooms.
It's a minute.
We're at the Capitol.
So it's a block away.
Yeah.
There is, I will send everyone, parking lot information for guest parking and such. But there will be 2 conference rooms in there that we, will, be able to use. So we will have a more, we will go back to the practice of having a, conference room that everybody knows where we are. So you no longer have to follow the breadcrumbs to get here.
We'll also have a fully functional kitchen.
When you say lower level.
No, that's ground level, because on the street, there's like the second level, and then there's, I don't know, I get lost in there somewhere. If you go on the street, you'll see the windows and you'll be able to see us in our office working hard.
Always.
You can look in right through the blinds. There's like, right in the parking lot, so you can spy on us.
Is it where Curb used to be?
It's where Curb used to be.
And have those
So is
blinds.
it a nice space?
It'll be a very nice space. I got a photo of some of the furniture in my office.
New furniture?
Yes.
Nice.
It was not nice when Curb was there.
Standing desks and yeah, should be good.
So,
Again, I'm happy to have a kitchen. Like we rinse my cup out, big for me.
so there is what my office, well, it's missing something, but that's generally what the carpet and furniture will look like.
And there's a conference.
There will be 2 conference rooms on that level. We will be sharing the space with the Ethics and Campaign Disclosure Board and also from Department of Administrative Service Fleet. There'll be about 5 or 6 employees in that area as well. So we lose our specific own space, but we will have 3 offices and 1 cubicle in that space. And then we'll have the conference rooms. So you guys will know where to go for your conference rooms. And there should be the electronics should be there. I'm not sure if we'll still need to use the OWL or if it'll all be implemented in the facility.
Nice.
Do you have you have a space for your staff? So you do containers.
So there'll be a little spot in my office, a little table that the staff can all meet at. All right, the next thing is the annual report. I don't know if you guys had a chance to review that. Luke is going to get me some more information for his bio. I talked to Joel. I don't know if there's any other corrections or changes anyone wanted to make to the annual report that we file with the legislature. And Barry, would you prefer that I have it reviewed and approved by you as deputy chair, or do you want me to work with Monica to review and approve it?
Does it take board action?
I have action needed, so.
You approve it now?
If you, yeah, I just want to know if there's changes that you want, I will make. You can approve it with those changes, subject to those changes.
Well, we do that. That's fine. Right? So we have a motion to approve it.
So moved.
So not on the agenda. It's
It says
on there.
2024 annual report action needed.
Wonderful. And corrected. Anybody have a motion to approve it?
Keep us out of jail.
Subject to Erica's review.
Yes.
All right, all in favor, say aye. Aye. Any opposed?
I'll second. I'll go do the second.
Thank you. All right.
Good.
Financial and budget update. So you guys have the figures on our budget. I did get notice on the governor's budget that is a requested increase for us, I believe, of $6,500. So I'm happy with an increase, which means hopefully I can keep my staff and we can all, continue to have a place to sit and all of that. Presentations, we have scheduled training for Pocahontas at the end of this month. The State Library Board is going to be doing, a number of years ago, I believe when Charlie Smithson was executive director, they did a video Q&A for librarians. They want to update that, so we'll be involved in that. I believe the taping of that is late February. District Court update, for those of you that are following it, the Teague v. Loeffler reconsideration opinion came out on January 9th. And that one deals with the closed session. The specific facts were a interview of an individual in closed session. The court basically stated that they should have done an inquiry into whether or not there was going to be irreparable harm done. In this reconsideration, they did state that the closed session recording should be released. I don't know, I believe that further review has been requested, but I haven't looked that up myself. I don't know if it.
Which,
for TV.
yeah, I don't know either. No, that's a good question.
I don't know if they can ask for both ask for reconsideration, but I don't know if there's been a request for further review by Supreme Court.
You send it to
The review of this.
Yeah.
Yeah.
There's a lot of discussion about a legislative request on that too. It's gonna change everybody's practice.
So we have gotten some questions on how to do evaluations and what this means and those kind of things. So, as most of you probably have. So. Oh, I did not send out the January 9th one. I could send it out to you if you'd like.
I'd like to say too.
I'll send it out to the board. On the district court update, Van Pelt is proceeding as discussed. In the Reha case, there has been a trial scheduling plan, but I did not see any dates on that one. In the Kilgore, case, a motion to dismiss, is currently pending. In the Ward case, a scheduling conference will be held in February 5th, 2025.
All right, next board meeting is February 20th, 1 o'clock in the new digs.
In the new digs.
Cool. All right. Since the agenda is complete, I will dismiss, adjourn the meeting.
You're here.
Yeah. I have to have anybody's consent.